Okay, so this video addresses the means for resolving disputes. And certainly disputes are a normal part of doing business. They come up all the time. And well-drafted contracts will have a mechanism for resolving disputes. And certainly the WTO, for example, has its own dispute resolving procedures, which include mediation, arbitration, and litigation. But outside of the WTO form, what I'd like to do is just discuss these three approaches independently and see how they work. Okay, so mediation, well, what is it? Well, basically, a mediator is just someone who helps the two parties communicate. And it's a very informal approach, and it's something that the parties, voluntarily do. They agree among themselves. Let's see how we can resolve the dispute. And what the mediator does is help them communicate, help them understand what each of the parties is saying in case there's some misunderstanding. And secondly, help them find common ground where they can agree and resolve it. So basically, it helps the parties communicate. It gets them talking, which is one of the fundamental rules of dispute resolution, get the parties talking. And it is a very informal way of doing it. Some of the advantages of our mediation, at first it's confidential. You just have the parties and the mediator, and he can be subject to a confidentiality agreement. And the parties can craft a solution themselves. It's what they agree to do. And the range of solutions is very flexible. I mean, they can really negotiate anything they want, including a new contract, if that's their choice. It's something they voluntarily do, and the process is very flexible, and you don't really need lawyers to do that. The disadvantages is you cannot force a party to engage in mediation. It's something they do voluntarily, unless the agreement says, the disputes will be resolved through mediation. And many times they have that in there. For big contracts, they'll try to get supervisors together to work something out, and if supervisors don't do it, then it goes to senior vice presidents, and if it does, senior vice presidents can't resolve it, it might go to the chief operating officer, and then finally possibly arbitration or litigation. But even if you do have mediation, there's no enforcement mechanism. You can't force the party into a solution. And meanwhile, the statute of limitations is running, meaning that if you have a legal claim for breach of contract and you have 3 years from the date of breach to file the claim, those 3 years are running while you're doing mediation. And the other party may know this, and they may be engaged in this in bad faith for the purposes of getting you to miss a filing date. Arbitration is a second means, and it is has a number of advantages in the sense that, first of all, you're not shopping around for a court. You pick an arbitrator, and many times the issue is, well, if you can't agree on a single arbitrator, then the contract may say, okay, each party shall select one arbitrator, and then those two arbitrators shall select a third arbitrator. So nobody has a real advantage in selecting the person who makes the decision. But the advantages, the procedures can be very flexible. I mean, they may designate the rules that apply to arbitration, but they can be very flexible. And you don't need lawyers to do this. You can have non-lawyers or scientific types, business types. And, your discovery can be very limited. You can agree to limit how much discovery you do or the time frame for doing this, something you can't really do with litigation unless the judge orders it for good cause. So those are some of the advantages. The disadvantages, if there are third parties involved in this dispute resolution, there's no formal way to force them into that proceeding. You don't have jurisdiction over them. You can't get them into that proceeding. Unlike a judge who can get them in there. It can be expensive. I mean, you're paying the arbitrators, and if you have 3 arbitrators, you're paying 3 times their daily rate, as opposed to litigation where the courts are technically free. So now you can enforce it if it's binding arbitration, and it says it's binding arbitration. Then Once the arbitrator issues a decision, if the other party does not comply, you can file a pleading in court requesting the court to order him to comply. But then you're into the lawsuit phase in that phase. And finally, litigation. Certainly you can force a party into litigation if the court has jurisdiction over them. You can get them into the courtroom. Even if they're if they're kicking and screaming, they have to come in or face a default judgment. And the courts are free, so you're not paying the judge. He's already paid by the public taxes. And the outcome is easily enforced because now, if the other party doesn't comply with the judge's decision, you simply file a pleading requesting enforcement, and he will order enforcement and impose fines and penalties if the third party or that party doesn't comply. The procedures are very strict, which is both a positive and a negative, meaning that if you're really digging for lots of detailed information, that other party is going to have to give it to you or face an order from a court if the court finds it's relevant. On the other hand, that kind of strict procedure can be very time-consuming, very costly, and can be used as a delaying tactic. So there are pluses and minuses to these strict procedures. Disadvantages are certainly no confidentiality here. These are public proceedings in open court, and as I said, discovery can be expensive if the parties are not cooperating, and these procedures can be used to delay the process, and you can also damage the business relationship in the process. You can get a reputation as being nasty or being someone who sues everybody all the time. And again, it depends. I mean, some companies want that reputation. They want a certain fear in customers and clients. If you breach any portion of the contract, we'll sue you. So that intimidation technique induces them to comply with every term in the contract. On the other hand, it can scare customers away because they don't want to be sued. So this can be used either way, and the litigation can take a long time, and your options to resolve, the kind of remedy you come up with is more limited to whatever the court can order, whatever its jurisdiction is, which would be damages, punitive damages, specific performance. It's more limited than what the parties could do in a mediation setting where they can craft anything they want. Where do you go for dispute resolution? Well, for litigation, a couple of interesting cases. The Zapata case is one of the lead Supreme Court cases, 1972, involving towing of a drilling rig from Louisiana to Italy, and a storm damaged the rig off the coast of Florida, so they towed it to Tampa, and then Zapata sued the company for negligence and breach of contract in Florida, and they challenged the court's jurisdiction, basically saying that the contract said that the dispute should be resolved in the London Court of Justice, not the courts of Florida, and they challenged that, and through the U.S. District Court and the Court of Appeals, saying that kind of waiver of jurisdiction in the U.S. courts was against public policy, and most witnesses were in the United States anyway, and the Supreme Court reversed the lower courts and told no, the clause is enforceable, because it was reasonable, it was negotiated, and there was no fraud or undue influence. In other words, that it was reasonable to agree to have a dispute resolution in London. The parties were there, they negotiated it, and neither party had undue bargaining power to force it on the other party, and there was no fraud or undue influence. So that's a key case, saying that the courts will recognize what the parties negotiate, as long as it's reasonable, negotiated, and no fraud or undue influence. Another interesting case is Bonney versus Lloyd's of London, involving the names. The plaintiffs were one of the names in a syndicate And as you know, Lloyd's has these names that put up a certain amount of money to insure a loss, and if they don't get called on to pay, they can make a lot of money. On the other hand, here the names were called, they were on the hook because whatever the event was that was insured happened, and they were on the hook for $300,000. And the agreement had an arbitration clause saying that it shall be arbitrated in England under English law. And they argued that this made them waive their rights under the 1933 and 34 Acts, and this was against public policy. And the Seventh Circuit Court of Appeals did not agree with them and said, no, this was reasonable given where the agreement was executed, location of Lloyd's of London, and specifically, there was no real substantive loss of rights by having them go to London, because under English law, there were remedies similar to Rule 10b-5, which is the fraud rule, SEC rule in the United States, that the British English law had a similar common law remedy, so there was no real loss in their substantive rights. Enforcing the judgment is important because you get, especially for international, you get a judgment in one court overseas, but the defendant is in another country. Can you get that enforced? And I think the Hubei Robinson helicopter case is an interesting case on that point, because here this was a decision by the courts in China. And in this case, Robinson was the U.S. company, and one of its helicopters crashed in the Yangtze River in 1994. And so the plaintiff, Hubei, filed in the trial courts, the low-level state courts in low-level trial courts in California, alleging negligence. Robinson themselves sought dismissal and transfer to the Chinese courts, saying that it was not convenient to have the trial in the United States, it should be in China. So the case was transferred and to the Hubei province, and the court properly served notice and process on Robinson. It physically was placed on the desk of the general counsel, and when the trial date came up, March 25th, Robinson simply did not appear. There was nobody from Robinson, lawyer, non-lawyer, anybody. And certainly in the United States, the judge would have immediately banged the gavel and ruled for the plaintiffs under a default judgment. But here, the Chinese judge tried to conduct a mini trial in any event, allowed the plaintiffs to call witnesses, and then made a ruling. And they issued their judgment against Robinson. And then several months later, about 4 months later, Robinson received a translated version of the court's order, but they never appealed it. They never challenged it. They did not file the appeal processes in the Chinese courts. Instead, they wrote to the Ministry of Justice trying to get this reversed, which was not the process. And so they lost their appeal rights. So the Chinese Hubei files in the U.S. District Court in the United States, saying, we have this judgment against Robinson from the Chinese courts. Would you please enforce this Chinese court decision? And the question is whether the U.S. courts would recognize the process and substantive decision by the Chinese court. And the answer was yes. They did honor it, and they ordered Robinson to pay. And the reason was everything the Chinese court did was in full conformity with the Hague Convention and the Federal Rules of Civil Procedure. They received notice and proper process about the proceeding. They received a judgment against them through their own fault by not showing up, and they waived their substantive rights by not filing an appeal. And the Uniform Foreign Money Judgments Recognition Act applies and requires the court to give full faith and credit to that foreign judgment. So the district court honored that Chinese court decision, and that decision was upheld by the Ninth Circuit in an unpublished opinion, which is at this website. And and that was March 2011. So this case shows not only that foreign judgments can be enforced in foreign courts, in those courts outside where the decision was made, but also that it's significant that this is a Chinese court decision that was enforceable and is enforceable in the United States, provided proper process and procedural and substantive due processes are followed. Okay, that completes the presentation on arbitration, litigation, mediation for dispute resolution procedures.